Lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are a part of, integral part of India. Lord, it could have said, technically it could have said that. But Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. Lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the President and the state government, can alter any part of the Constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3, impact of Article 370 was to deprive the residents of Jammu, Kashmir and Ladakh from being treated at par with their fellow citizens. My lord, therefore, my lord, I am saying that this also is one suggestive indication that framers never intended it to be permanent. Then, Lord, this is the entire provision. Lord, this is very important. This is the entire provision in the Constitution where application of not only Constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. Such a, my lord, drastic provision could never have been intended to remain perennially, permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, my lord, it is a goal of equivalence, my lord, I have already said, my lord, in the judgment which I read, that temporary problem, my lord, provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences. Because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the Constitution. And to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. My lord, then I have said, my lord, kindly examine it from the people's angle. Then 370 is interpreted the way petitioners interpret. 371 would become permanent, which is not only impermissible and not envisaged, but would result in The unconstitutional provision remaining in the constitution and operating. Well, unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. My lord, then 13, my lord, is most important, my lord. Sub-article 3. The proviso to sub-article 3 was to remain in operation. My lord, I have already said these are the 5 possible recommendations that Constituent Assembly could have given. Your lordships have seen that. Then, my lord, B. Once the Jammu and Kashmir Constituent Assembly ceased to exist, the proviso to Article 370 sub-article 3 itself ceases to exist, and the President becomes the sole repository of power under Article 370 sub-article 3, which is coupled with his duty to exercise in the interest of residents of Jammu and Kashmir without any recommendation. It is for this reason that power is conferred upon the highest political executive, who is responsible to the Parliament, who in turn is responsible to we the people of India. It is thus clear that Parliament, while framing the proviso, merely gave an option to the Constituent Assembly to make recommendation till its life. But 15 is important. This is how the petitioners want your lordships to read. Notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly of the state referred to in clause B, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications. The very purpose that the concept of recommendation is provided in the proviso, Lord, leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes. Lord, they
according to you, the proviso will not govern the substantive provision.
Cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become OTOs, the main provision does not become OTOs. Then the conditionality attached goes. Tail cannot verify. Yes, my learned friend is right. If this interpretation to Article 373 is not accepted and the President's power is under Article 373 is taken away, merely because the Constituent Assembly has ceased to exist, without making any recommendation, it would create a devastating situation which could never have been envisaged by the framers of the Constitution, nor ever been conceived. If the President cannot exercise the powers under Clause 3, it would mean that existence and exercise of power of the President of India provided for in the Constitution is dependent upon some decision or lack of it by a different body. Can we read a Constitution that President's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation.